Hi, I'm Professor Mark Grabowski, and this short video lecture will discuss how Internet laws are made. In the United States, there are 5 sources of Internet law: constitutional, statutory, administrative, executive, and judicial. Let's start with constitutional law. This refers to the law that comes directly from the U.S. Constitution and its amendments, and in some cases, the constitutions of the states. A variety of constitutional amendments apply to the Internet, including the First Amendment, which protects online speech. Second, there is statutory law. This refers to laws made by the elected governmental bodies such as the U.S. Congress, state legislatures, county commissions, and city councils. On the federal level, congressional action affects intellectual property rights, such as copyright. It can also make laws on how to regulate Internet service providers, such as Comcast, Verizon, and Time Warner. And Congress establishes online advertising practices. State legislatures are responsible for making laws regarding online defamation and online privacy, sales tax on e-commerce transactions, among other laws. City and county governments pass local laws, often referred to as ordinances, that may regulate where Internet service providers can construct Internet infrastructure, such as wires and cables. One simplified explanation on the difference between constitutional law and statutory law is to say that constitutional law deals with large and abstract issues, while statutory laws deal with matters that are specific and concrete. For example, constitutional law is vague. The First Amendment, for instance, provides freedom of the press. But what exactly does freedom of the press mean? Well, Congress, through statutory law, makes these vague concepts more concrete. For example, Congress passed a statute known as the Freedom of Information Act that provides journalists with access to government records. The third source of law is administrative law. Administrative law refers to rules and regulations made by administrative agencies that are part of the executive branch of the federal or state government. After legislative bodies such as Congress pass a new statute, it's often up to an administrative agency to work out the details of how the law will work and to enforce it. For example, if Congress were to pass a law requiring that new computers be manufactured with environmentally friendly parts, the Environmental Protection Agency might determine which materials are environmentally friendly and which are not. Thus, the agency would affect policy. At the federal level, agencies that have responsibilities in Internet law include the Federal Communications Commission, which oversees Internet service providers, the Federal Trade Commission, which handles online advertising and online marketing, the Federal Elections Commission, which oversees online political advertising, the U.S. Patent and Trademark Office, which is in charge of intellectual property, and the Department of Justice, which is responsible for cybercrimes. Executive actions, or the fourth way that laws can be made, are those actions taken by chief executives such as the United States President, state governors, city mayors, or county managers. These actions have little effect on Internet law. For example, there are not many things that the President can do without congressional approval that would have a direct effect on the Internet, except perhaps in a grave national emergency such as a nuclear war. The President, though, has an indirect effect on Internet law through appointments of judges to federal courts, including the Supreme Court, and through appointments of heads of administrative bodies such as the Federal Communications Commission and Federal Trade Commission. The final way that Internet laws are made in America is through the judiciary or through judges. Courts can affect Internet law in many ways. Sometimes when Congress passes a new law, it is challenged by individuals or organizations, such as the American Civil Liberties Union. A judge then decides whether the law is unconstitutional and should be disallowed. Sometimes people or organizations may sue another party because they believe their rights have been violated. For example, a person may sue a blogger for defamation, and a judge will have to determine whether defamation occurred. And sometimes people may be arrested for committing cybercrimes, but insist they're innocent. Since every American charged with a crime has the right to a trial, a judge will then hear the criminal case and decide whether any laws have been broken. These court rulings are sometimes referred to as case law or judge-made law. Most areas of internet law are neatly divided among the federal, state, and local governments. But because of the broad nature of the internet business, certain categories of cyberspace law are assigned to each of the three levels, and in some cases, responsibility is shared. So now you know how internet laws get made in America. Once again, this has been Professor Mark Grabowski. If you're in my internet law course and have any questions, please email me at mgrabowski@adelphi.edu. Thanks for watching.